Hi, I'm Etta Spencer. You want to prevent war? How about that? Well, we have somebody here who has some idea how the best way to prevent war. So we're going to talk about that today. He has some definite notions about what we have to do. And I'm very happy to welcome James Ranney here, who is, I think, in Delaware, or no, Philadelphia, aren't you?
Yes.
Okay. Good morning, Dr. Ranney.
Good morning.
So let's see, you have a book, and I've looked at the little pieces of your book. I haven't read the whole thing. Yeah, you can hold it up if you have a
There we
copy.
go.
There it is.
Ta-da.
So let's see, where's that? World peace through law. Well, that's a good hint. You think we're going to get world peace through law? Well, very good. How's that going to happen, and why is it that that's the best approach?
Well, it's an old idea, actually. I take no pride of authorship. It's an idea that stems back at least to Jeremy Bentham in 1789,
Oh,
at the first such proposal, and includes 5 American presidents, 4 of them Republicans, by the way.
yeah.
Also Winston Churchill and Benjamin Franklin. And it basically would substitute the rule of law, meaning law in the broadest sense, including the international dispute resolution mechanisms that precede resort to law, such as mediation and arbitration.
Mhm.
So the big point that I would like to make, and the reason I want to be on the Zoom video, I guess, is that I think the missing ingredient from peace activists, and in particular those who are favoring abolition of nuclear weapons, the missing ingredient is this international dispute resolution. That is the crux of the book's proposal.
Mhm.
And the crux for the argument for that position is as follows: that number one, we can pretty much agree that we need to abolish war. We need to abolish war, as JFK said, or war will abolish us. Quoting, by the way, H.G. Wells,
Oh,
1921. I discovered that when I was at the World War I Museum, by the way. I was shocked to see that quote. I thought, oh, that's JFK. Wait a second. It's H.G. Wells. So if we start from that proposition, that means, it seems any third grader could say, we need alternatives to war,
mhm.
right? And that in turn spells the need for international alternative dispute resolution. And lawyers have become sufficiently familiar with alternative dispute resolution to call it ADR. So if I lapse into that, you'll perhaps forgive me. And then the final stage after alternative dispute resolution is compulsory international dispute resolution. And if you have some time, I will explain what's going to make it compulsory. But I'll pause, take a deep breath, and stop.
Well, let me ask you, the first thing that occurs to me is, my impression is that before or about the time of World War One, when people talked about alternatives to war, it generally involved the word arbitration. For
Yes.
example, there are still places, for example, the Swedish Peace and Arbitration Society still carries
Yes.
that name. It was a very common notion that
It was.
you would submit your dispute to some sort of tribunal, and they
Mhm.
would have binding decisions, issued binding decisions, if I'm not
Yes.
mistaken. Now, I
That's
never
right.
looked into that mechanism. But it sounds like that's the final stage of what you're proposing, a binding and compulsory arbitration.
No, it's actually the third of 4 stages.
All
The
right.
final stage would be adjudication in the World Court.
Okay.
And by the way, those who think that's preposterous need to realize that Mikhail Gorbachev proposed exactly that in 1987. And there were discussions for a couple of years, and then it was forgotten. And the arbitration concept was indeed very, very prominent in the early 1900s. It's the whole concept of international dispute resolution has not been mentioned in any significant way by any peace activists for the last 50 or 60 years. The last significant mention of it was in the McCloy-Zorin Agreement of 1961, under Eisenhower and JFK. And John J. McCloy was a very establishment figure. He'd been president of Chase Manhattan. He was president of the Council on Foreign Relations. He was a very, very establishment, seemingly moderate conservative, but they purposely, JFK picked him to represent a liberal view.
McCloy,
John J. McCloy.
Part of the McCloy-Zorin agreement or something. Yeah. Okay.
Almost nobody but you, any historian, they've forgotten this whole agreement. In fact, there's a book by McKnight and Souter called The Forgotten Treaties, and it's about this exact treaty, which originally was agreed to by the United Nations, but then it never really went anywhere. It never got passed. 1961. And one of my
I
students,
couldn't tell you any of the details of what it involved, but okay. Now let me pause with another question, which is that an arbitration kind of notion. It really depends on having both sides, if I'm not mistaken, having both sides pick the arbitrator, or the whatever the word is for the person in charge, to make the decisions and then agree to be bound by his or her judgment. But that's different from what I think is the assumption about how we would get agreements now, which is that every country or all of the affected countries would reach some sort of treaty, and that the treaty would spell out every possible contingency that might arise, so that we would know exactly what to do if somebody supposedly violated it. And then it would go to the World Court for decision about who violated what. And that's different from the kind of personal qualities. I mean, in that case, of course, it shouldn't matter at all what the personality or the predilections of the judge might be. It would be entirely determined by the content of the treaty, right? So those are totally different notions of how you would get an agreement. And I think when you talk about law, that's what I think of, that people agree to some rule, and then the rule has to be so clear that it's very obvious when somebody has violated it, and it's the violation of the rule that, or the law, that is makes a person or a certain country culpable, and the other side should win. That's different from having the personal qualities of the judge enter into it, and their personal opinion about what is just and what is right.
Well, it is true that in my book, I have a much broader concept of law than the concept that you've been talking about just now.
Mm-hmm.
It would not be dependent upon existing law. And in fact, it is true that each stage of this compulsory international dispute resolution process would be quite different. Stage one, which I haven't even mentioned, is compulsory negotiation, which according to two historians could have prevented World War I.
Mm-hmm.
That'd be worth doing. Compulsory mediation is the second stage, and you could probably solve 98% of all international conflict just by using the voluntary intervention of a mediator who has no power to bind sovereign countries. Arbitration, however, is quite different, and it gets much more intrusive, and it is a risky proposition. And countries, when Teddy Roosevelt proposed it and William Howard Taft proposed it, the Republicans in the Senate rejected it because they viewed it as being too intrusive upon the individual country's decision making. The final stage, though, is not just existing international treaties. You mentioned in passing the fact that they need to have all these things spelled out in detail in advance. They would not be spelled out in advance, and you would be subjecting yourself to a process that is somewhat more indeterminate than you would like, unless, of course, there is clear existing law, which stands as the ultimate backup in the fourth stage. but maybe I've gone far enough. I'll let you
No,
ask
no,
another.
now then that's where it gets interesting. It would be, there are international laws, obviously, and the arbitrator, is that the word for it? The person or persons who are the decision making judge in the case.
The
Uh,
judge would be the fourth stage, the arbitrator would be the third stage, and the mediator is the second stage.
but the arbitrator is the word for the authority who's going to make the judgment, right?
In the arbitration stage.
All right, yeah. Now, but then the arbitrator does not have free reign to just come up with any judgment that he thinks appropriate, but would in every case be bound by existing international law. And it's only in the case where existing international law is not clear enough or it is maybe wrong. What if they think that the international law is really a bad law and
Could happen.
and shouldn't be applied? What would be the verdict in such a case?
Well, by the way, it might not be a single arbitrator. It might be a panel of arbitrators.
Right. Okay.
But you'd still end up really having the decision come down to frequently just one person's view of things.
Mm-hmm.
And the law is sufficiently malleable and uncertain, even existing international law, that there would probably be many instances in which the arbitrator technically could decide existing international law is unjust, and I fine for somebody else. That could happen. And then the other party would be able to go up to the International Court of Justice and you'd either win or lose. And as Eisenhower said, it's better to win or lose a point now and then than to end the world with World War III or some such thing. It's in my book.
Yeah, Eisenhower was on your side on this matter.
He was. He's the most prominent president, along with Grant and Teddy Roosevelt and William Howard Taft and John F. Kennedy. All favored some version or another of world peace through law. It's not even mentioned nowadays, but it used to be very, very common.
I guess I'm a bit put off by calling it law, because in a way, what you're saying is that it's not law. It's the good judgment of sound-minded people that both sides, I presume, both sides would have to accept the nominations to that panel of adjudicators. Right?
I agree with you entirely. And in fact, I had a big battle with my publisher on the name of my book. All right. I wanted to call it Securing Lasting Peace. But he said, oh, no, that's to this, to that. So I went back to this old title that I originally used when I first started work on the book 5 or 6 years ago, which is World Peace Through Law. But then I have a paragraph in the first chapter of the book explaining I have a little different definition of law that includes all these mediation and arbitration procedures that are now part of law considered. I mean, the law schools, all right. When I went to law school, there were no courses in alternative dispute resolution. Now, every law school in the country has at least one and frequently 3 or 4 courses in the subject. It's increased 10 and 20-fold in the last 20, 30 years domestically. Mm-hmm. Now it needs to happen at the international level. And it's begun to happen at the international level. There are organizations dealing with international arbitration that have been around for 15 years.
Mm-hmm. Yes, I know. I realize that lawyers have, in many cases, begun becoming mediators or even family counselors in a way.
There are some attorneys.
Usually that is, I presume, mostly limited to family law, divorce cases and that sort of thing, or maybe business. I don't even know many cases in which a big corporation would subject itself to the decision-making process that you're describing. They would probably
it's become increasingly frequent in all kinds of cases, including business cases. A lot of, in fact, the accusation that's made against arbitration is that too many large corporations have arbitration clauses in their contracts, and they have some advantage, presumably, in arbitration. Of course, that's another issue, but it's true that there is that perception out there. But arbitration has become very, very common in all sorts of cases. I use it myself in personal injury cases. Worked out pretty darn well. The case eventually settled because of the efforts of mediators. It was a retired judge that we used.
Mhm.
Many months later.
Okay, well, look, as a peace activist, it's not going to be hard to convince me that anything that you're proposing is going to be better than war.
All
So
right.
I'm already halfway there, but
Right.
you're going to have to spell out to me, if you will, these four stages, and
Right.
and why you think that has more hope of being accepted than the very prolonged process of developing a full set of international laws that are really binding on every country in the world. That I would agree that that is getting to having a real international parliament making international laws, and an international court that can enforce them, and even an international constabulary, if you will, that
Sure.
that could enforce them. That looks to me like a very long process, and there are going to be a lot of bumps on the road to get there. So if you could show me that there's any prospect of getting people to accept arbitration as a simpler solution, um, I'm eager to be convinced.
Sure. I used to be a World Federalist. And so I did hold out hope for a global parliament and a global executive and all that. And then I became convinced that it was not going to happen soon enough to save humanity from the nuclear age. And so there's a book that was written by Hans Kelsen in 1944 called Peace Through Law, which not surprisingly proposes world peace through law in the same exact way that I proposed it. Actually, it's not an original idea. It's so unoriginal. In fact, the whole concept of using international dispute resolution is like a tautology. We need alternatives to war. Alternatives to war means alternative dispute resolution. And so I think that, again, has been a missing ingredient from discussions by peace activists all up and down. And the possibility of that being happening in the near future, as Hans Kelsen points out, is about 1,000,000 times greater than real federalism coming to pass anytime soon. In other words, it's going to be difficult. It's a hard haul. It's hard to convince countries, the bully boys of the world, the United States and Russia and so on, from doing the things that they have done, like Crimea and Nicaragua and what have you, and in the second Iraq War. Because we have our guilty little pleasures, you might call them. You have this big, wonderful military. Why not use it, et cetera? And so there's a tendency to resort to military means. Gradually, we need to become disabused of that, of course, and through all the normal processes that the peace movement is bringing to bear, with an emphasis upon gender rights, with an emphasis upon education, with an emphasis on all these things that are necessary to happen before the world is ready for compulsory international dispute resolution. Let me define that word compulsory because I've used it a couple of times.
Mm-hmm.
What will make it compulsory? Everyone asks, right? And the answer is nothing. What it would have to be is an increasingly strong norm, in addition to a treaty requiring resort to international dispute resolution, that would need to grow up eventually a norm. And there's a great quote from the 1830s by Alexis de Tocqueville, which goes something like this. He says, "You can have the best laws and the best constitution on the books, but if you lack the norms, it can all fall into disaster." And just contrary-wise, you can have the poorest laws and the lousiest constitution, but if you have the right norms, all will be amazingly well. And so that's the whole point. That's what would make it eventually come to pass. And what would make that come to pass in turn is one word: education. There's a quote that I have in my book from a longtime World Federalist, ironically, Bill Wickersham. And I don't have the date because it was undated. He sent me a draft of an early speech about 1984. And he said something like this. He said, "Peace activists confront me all the time and they say, well, what can I do to abolish nuclear weapons? It's just too big a topic." And he says, yes, there is something you can do. You can educate yourself and others. He says, in order to escape from the nuclear warfare trap, we will need fundamental social and political change. And fundamental social and political change requires attitudinal change. And attitudinal change requires education. Educating ourselves and educating others. And by the way, in terms of educating ourselves, I recommend, not surprisingly, my own book, which has solutions proposed, all right, plus two others. Out of the thousands of books I've read, probably 4,000 or 5,000, there's a book by Daniel Ellsberg called The Doomsday Machine. Excellent insights. And then the second book is by William Perry, My Journey at the Nuclear Brink. If you read those three books,
I have read Perry's book. I haven't read the one that you mentioned by Ellsberg, and I've only looked a little at yours. So
right,
I'm not well educated yet. You've got to educate me.
I have a list I used to make up, I laughingly called World Peace Through Reading.
Now, let me raise an objection, which is that education, in a way, is comes as a matter of fashion. We promote certain issues and overlook others, really for no special reason except that this is what's in these days.
True.
I mean, the issue, well, I'm going to raise a lot of hackles here if I say this.
Go ahead.
Let me give you the example. In the last couple of years, Indigenous rights has become a very important issue. Now, it wasn't before, and it may not be again. There will be some other issue that'll come up that will maybe take precedence over that in the public discourse. But now when you have a meeting where I live, you're supposed to say the acknowledgement that we're on Indian territory, et cetera.
Right.
And this is just kind of a, excuse the word, fad, frankly. It has symbolic value, and I'm not opposed to doing it, but I'm saying, now let's suppose we had arbitration and everybody the outcome, you could foresee that the outcome is going to be dependent on the type of person that you agree is going to be the arbitrator or arbitrators. And you know what the position is of all of the candidates for that role vis-a-vis Indigenous rights. Okay, so the answer you're going to get is foretellable before you appoint the person, based on whether or not this is a person who's particularly into Indigenous rights or not. And therefore your dispute is already going to have to be fought out someplace else before you even get to court, or before you even set up the tribunal or whatever. This is in a way similar, if you will, to the dispute within, let's say, the U.S. Supreme Court between the strict constitutional conservative members of the Supreme Court and the progressive members who say that you have to look at what's going on in society today that's happened since the Constitution was written and take account of the new social developments. So that, what people, when you appoint a person to the Supreme Court, you know that you're going to affect the outcome of future cases, because you know whether you've got a conservative or a progressive person on the court, on the bench. So in a way, doesn't that defeat the whole idea that you can solve the problem by arbitration? Because the answer depends on who the arbitrators are, and therefore the dispute has to be resolved before you get to the dispute resolution process.
Well, when you say it depends on the person involved, that's going to inevitably be true. The emphasis upon world peace through law perhaps has kind of a misleading implication that there's going to be this definite rule of law. And even at the adjudicative stage, I taught international law a couple of times, and it's surprising how often there really isn't anything very definite to land your feet on. So the expectation that somehow some kind of formula for peace, which my book is going to solve all of our problems automatically is mistaken.
Mm-hmm.
It's still going to depend upon ordinary people doing the best they can under difficult circumstances. The only thing I'd point out, by the way, is that it is true that both arbitration and adjudication involve severe intrusions into sovereignty. But preceding that is mediation. That's where my hope lies. I think 98% of all conflicts would be resolvable by mediation. I've had tremendous success, by the way, personally with mediation, so maybe that's why I feel that way. For instance, I mentioned this one case that I had involving electroshock therapy that went bad, and this person was put into status epilepticus, which caused a coma and permanent brain injury. And we, the opposing counsel and I, through a process that was set up in Montana, found an arbitrator or a mediator that we liked, a retired judge, fantastic guy, Judge Gordon Bennett. And we spent the better part of a day in mediation. We didn't solve it that day. We solved it about 9 months later, but it was in part because of the work of that mediation. That mediation moved the other side along to where they realized, that we were serious. And so what I'm saying is that you need to consider the whole system of international dispute resolution, and the fact that there may be individual problems with arbitration in particular, or even adjudication, doesn't detract from overall, although the whole system may work in a fashion that it doesn't have to be in stepwise fashion. The parties can agree to move more rapidly or with consent through various stages.
You said you thought World War I could have been avoided with mediation.
That's right.
Elaborate, if you will, because I can't fill in the blanks there.
Yeah, I cite two authors. I think one's name is Lusky, and the other author is who the name I don't remember, but he says this. He says there have been 20,000 books written on World War I, the origins of World War I. And by the way, a person reading steadily an entire lifetime would not read those 20,000 books, interesting enough. And he said, we still haven't figured out what the hell caused World War I. And he says, so if we can't figure out what even caused it, surely there should have been some way to prevent it, is what he says. So anyway, I don't know whether they're right or wrong.
That's an amazing statement right there, isn't it? Of course, I don't know. I've never studied it that closely at all. I really have very, very hazy theories about World War I, but that's a shocking statement that we can't. Surely we could give some causes, but maybe there are different weights that we've attached to them, and if you don't know what the causes were, why would you think that mediation would help?
I don't know. All I'm saying is I quoted verbatim two authors, two historians who are trained in history, who said that they thought World War I could have been prevented by mediation.
Well, I mean, maybe so, but then I guess I'd have to read those books myself and figure out whether they give good reasons for it, because I wouldn't know. I wouldn't, if I wouldn't be a very good mediator, because I take sides and I get angry. I would be, I have taught courses on conflict resolution, but I'm the worst person to be a conflict resolver, because I get mean.
I have similar difficulties. I was repeatedly told by the people who trained in mediation that you're not supposed to intrude your own views at all, and that you're supposed to let the parties themselves solve the problem, right? And I resisted that notion mightily. I put major pressure on both sides, contrary to what all the mediators trained us to do. And I had the highest disposition rate of any of the mediators that they had in Missoula County. And I did it. I did one with the head of one of the training programs, and he got done. He says, "You realize that we violated all the rules, don't you?" I said, "Oh yes, I know." So we did. I mean, I don't know. A lot of these people that I know who are mediators, I don't know. I don't want to go into it. I call them AFF, W, LLL, airy-fairy, fuzzy-wuzzy, left-leaning liberals. All right. And I still remember this one guy, I should go into this great big guy, and he's trying to resolve this case that we had. It was a kind of a nothing burger case. And this person who was the defendant, who was the plaintiff, he was suing my client. It involved a horse in a pasture. That's all I can recall. And this guy looked and acted exactly like Hitler. This guy was a real Nazi. And I remember sitting there during our mediation session, silently laughing at this idiot, this mediator who was trying to resolve it. I thought, you're getting nowhere with this guy because he's an idiot. And sure enough, when we went to court, we kicked his behind all over the place because he was a total idiot. Well, so anyway, I digress, perhaps.
No, let me go ahead and tell me the outcome, because I would predict I have an idea how it might work out. Go ahead. What was the outcome?
Well, the outcome is we won the case because
I'm not sure you would always win the case. And in fact, the problem is that most of your cases are going to involve guys like that. Maybe they don't look like Hitler, maybe they don't act like Hitler, but they certainly are nasty people. And this is what I have a very pessimistic view of human nature lately, because I've been watching all the political decisions being made by voters, which makes me wonder what the hell I'm going to do about believing in democracy anymore. Because I think the judgment of the average person is so susceptible to influence by personal interest, but also social relationships. You know, people belong to groups and they have friends and they go along with their tribe. And even if it's totally irrational and contrary to common sense and contrary to the law as well. But so what are you going to do in a case like that? You're going to mediate two guys who have totally different commitments for whatever reason, and they're irrational, and whether they look like Hitler or Donald Trump, they're the same personality, you know, you cannot get them to move.
Yeah. In fact, what I used to argue in my own defense for being intrusive on mediations was that, well, if these people were good at agreement and figuring things out and reconciliation, they wouldn't have been in this court battle in the first place.
Yeah.
They would have figured it out. So it is true. I mean, not every case gets resolved by mediation. I'm just saying that actually about 90% or more, Kofi Annan made some statement about how mediation has grown in recent decades. He said we've solved more conflicts by mediation than we have in the prior 2 centuries, just in the last 2 decades. So it's becoming very frequent.
Well,
very popular.
Now you have cheered me up a little bit, because I didn't know that it was more successful lately. I could see how it might become more popular. I mean, all kinds of things become popular for whatever reason, but the success rate of getting people to be satisfied with the outcome, if that is improving, then there's hope for humankind.
Perhaps.
Right? And
Yes.
Are you telling me that the satisfaction of the litigants is happier at the end than it used to be on the whole?
Well, I think those who participate in mediation, and I've participated in many dozens of mediations, it generally improves each party's understanding of the other side's position. Mm-hmm. That frequently occurs. And in any event, it's not always just the happiness of the parties that's in question. If they are successfully able to mediate, even if both sides end up grumbling, maybe society has the benefit, especially if we're talking about international dispute resolution, where you're talking about war being the alternative. Maybe mediation even between two unhappy countries is preferable to a war between those same two countries.
Okay, now you realize also that most of the wars today, or most of the conflicts today, are not international wars, but
I knew you were going there. The minute I said between two countries. Well, I had a wonderful dialogue with one of your prior guests, Colin Archer, and he raised that issue right off the bat. And all I said was, I quoted from page 91 of my book, which said, well, the fact that it doesn't explicitly deal with intra-state conflict should not be held against it if it solves all the major conflict, i.e. humanity extinguishing major wars. And you say, okay, yeah, I agree with that. But some of the techniques that are usable, that are of international dispute resolution, are fully applicable to civil wars. It might be very helpful.
Okay. But we now have to get to the point, the final stage in this thing, the compulsory nature of it. You're going to force countries or even internal combatants, if it's a civil war, to come to the table and listen and make their case and then accept the verdict. How are you going
Yes.
to get them to do that?
That's the third part of my proposal. I have a three-part proposal. I think a necessary
I
prelude.
short-circuited the whole thing, so maybe you better go through all 4 steps.
Well, it's a 3-step proposal, and the second step has 4 stages. The central crux of the proposal is compulsory international dispute resolution, as I've said. A necessary prelude, I think, to that, at least as a practical matter, would be abolition of nuclear weapons and certain reductions in conventional forces that would be necessarily concomitant in order to get, for instance, Russia to agree to abolition. So I think a necessary prelude psychologically, can you imagine the psychological boost that it would give? Countries would suddenly have reason to trust, resort to international dispute resolution if they didn't have to worry about nuclear weapons. If they got rid of their nuclear weapons, it would give a psychological boost to the second stage. The third stage, which is the response to your question, is the existence of a UN peace force. And the pacifists give me a hard time with it all the time. Mm. But I cite numerous people, including Randall Forsberg at MIT, who I've met, who argued very well against the pacifists in a book that was written.
I'm sorry, who at MIT?
Randall Forsberg.
Oh, okay.
She passed away in about, I think, 2005, a few months after I met her. Mm-hmm. And she said, there were others who believe just as strongly that in order to secure peace, we're going to need some kind of international peace force, that the use of force in some instances is necessary. Although I would add this, I think it may not be as necessary as might be supposed by all these prior proposals that have been made over the years for world peace through law. Teddy Roosevelt, in particular, spent a lot of time emphasizing the need for some kind of international peace force. But I think that if you get countries to agree to accept the results of international dispute resolution, once a verdict comes in, and William Howard Taft said this, then they're likely to accept it without the need to resort to any kind of a UN peace force. And there's all sorts of possible, and we could spend another 3 hours talking about the ins and outs of a UN peace force, because in my book, I deal very candidly with the most serious objections that have been made by some very mainstream international legal scholars, international relations scholars, to a UN peace force.
Well, let's just deal with one right now. And the one that haunts me, because I'm basically in favor of an international peace service of some kind, which would certainly involve coercive capacity, but not be limited to it. The thing that would bother me and give me pause is the notion that if you have one major army in the world and nobody strong enough to stand up to it, then any kind of any dictator who gets in power and gets control of that army has a free pass, and yes. You can't overcome a dictatorship or totalitarian system. So that would be my main and maybe only objection.
No, that's a logical objection, and there's actually in this chapter 10 of my book a good 2 or 3 dozen objections that I bring up to this proposal, and I'm not sure what the overall answer is. In my book, I propose there's a control mechanism on this UN peace service, or like I point out, there could be all sorts of peace services that would be focusing on things that are not related to the military at all. But assuming you are talking about the military component, I think in terms of the control mechanism, you might need to use, and this is just a suggestion as to what might be acceptable to every country in the world, a combination of weighted voting and a combination of weighted majority voting. So that you might end up saying that, for instance, no one country could have more than a certain percentage of the weighted vote, and there'd be a natural break upon permitting a UN peace force to actually engage in forceful maneuvers.
Yeah, but what's going
But
to stop them?
yeah, I know.
See, there's
Um,
there's the rub. You might have very good policies, but if some dictator gets hold of the regime of the army, policies don't count.
yeah, no, we've seen that in our own country, of course.
Yep.
Things can go all to hell in a hurry.
Mm-hmm.
And I'm not sure what the answer is. I mean, I have some answer in my book that I can't even recall off the top of my head.
Mm-hmm.
But I think there is no guarantee from any of these proposals. My own proposal does have the advantage of being very popular with some mainstream thinkers, including 4 out of 5 presidents who are Republicans. And so that's although the Republican Party bears no relationship to the old Republican Party.
Mm-hmm.
And Winston Churchill favored it.
Mm-hmm.
Benjamin Franklin favored it. The whole idea, by the way, of international dispute resolution goes back further than anybody else has discovered. I discovered that it was first proposed by King George of Bohemia, Czechoslovakia, in 1464. And you'll say, how can that possibly be possible? He hired some Jewish lawyer from Paris, all right, to draft a draft treaty attached to the book, which I cite in my book. In Article 19, he says, well, we're going to have total control based on equity decisions on everybody. You know, it's amazing. It's in the whole history. There were 4 people on horseback who headed to Paris to try to get them to the king and his counselors to agree to this proposal. And the clerics opposed it because they felt it would take power away from them. And they were right, it would have. Well, anyway, it's a long story. It's an amazing story.
Okay, look, let's go back to your step by step. I think I deflected you when you
Sure. All right.
finish.
Yeah, the proposal is basically to build upon the existing alternative dispute resolution mechanisms which exist. And the UN Charter lists several other things that I basically say, well, they're just one aspect or another of these basic 4. The basic 4, though, are compulsory mediation. And again, 2 historians believe that World War I could have been prevented if they had compulsory mediation. All right. And by the way, in regard to, that's just that's.
But wait a minute, I'm still stuck on how you're going to make it compulsory.
Again, an increasingly strong international norm. That's the answer. You'll say, oh, well, what's the chance of that? I don't know. Who knows? And predictions either way, right now, by anybody, by the poo-poors or those who are in favor of it, aren't worth anything.
That's true, but norms are as fickle as can be. I mean, we see people who 10 years ago were great believers in democracy and liberalism and all of that, and they're now out there as populists climbing the walls of Congress, So,
It's
norms are not as strong as we'd like to think they are. And maybe they shouldn't be anyway, because you can have some bad norms. So there, I'm trying to be a problem for you because you have a really brilliant idea. It is, I think, I think you're really onto something. I can't really disagree with you, but I can throw sand.
That's all right. No, it's very good because it's very useful. I'm constantly updating my thinking on this proposal, and nothing that I've seen has convinced me that I'm off base in any major respect that I can think of. I'm pretty happy with the book, the way it turned out. I'm very proud of the way it came out. I put everything I had into it. I realize I have certain limitations, but I have certain advantages that not everybody else has. For instance, the fact that I was no longer having to teach full time and be on all the faculty committees and publish your parish, et cetera, et cetera. I could devote 10 hours a day to reading. I call it world peace through reading. I've been reading since 1983 when I saw certain directions that gave me hope on the peace issue. And I was permitted by the dean and the faculty curriculum committee to teach a seminar, which we laughingly called Law and World Peace. So that was the origins of the idea. That's when I was still sort of a World Federalist, or at least I thought I might be.
The wonders of retirement. I am
yes.
myself, and it's a great privilege. I'm even enjoying my solitude as a result of the curtailment of all the activities I used to have to do before COVID came along. So there are bright sides to all kinds of misfortunes.
Right. Well, I started to say is that how many people are there in the world? I'm going to sound like I'm bragging a lot, which I am. I do brag for amount. How many people have had 3 years of physics? And by the way, on the last exam, I got the high A in the course, right? Plus, how many have taught international law twice? How many have all the background that I have in alternative dispute resolution, both mediation and arbitration? And I go on, I list 8 different things, history, et cetera, et cetera. How many people do I know in the world who have all of those characteristics? You know, that much background in international law, et cetera. And
I agree. Yeah.
I don't know anybody.
That's fine. Yeah. I'm not going to challenge you. I've enjoyed this
very much. I like it. You're wonderful. I really do like your style.
I really do think this is an important addition to the mix. I'm not sure that we can say, yes, this is, he's absolutely right because of all the things, all the concerns that I've raised and that I think you share. I mean, when you say you were a little worried about calling it world peace through law because arbitration and mediation are not exactly the application of real law, but personal.
Well, they didn't used to be viewed as part of law at all, but they are very much nowadays. But you're right.
It reminds me of what Gandhi didn't much like being a lawyer and kind of gave it up. But he harked back to the time when in a village, they would all go sit under the tree and the wise man of the village or the wise persons would listen to the issue and make the decision. In a way, that's what you're suggesting, that we should go back to using common sense and good judgment and defer to people who have some good sense.
Yeah, that's what I am suggesting. That's correct.
Right. Mm-hmm. Well, I kind of agree, but I'm not sure how to get there either. I'm not sure that that's going to be much easier to reach than the idea of having really well-defined laws and a really, big institutions for implementing them. So we've had a wonderful conversation. It's time to end, but I've enjoyed this enormously. I'm going to share it as widely as I can because I think this is what you're talking about is a bunch of issues that, there are many implications of what you're talking about, many side tracks we could go off on. And I think these are all issues that everybody should be reflecting on because it may be that your approach is the way to go. Don't know.
Well, thank you. Thanks very much, Mela. Thank you.
Okay, it's been fun.
Very good.
Yeah, take care. Bye.
Yeah, bye-bye.